Hey everyone, how are you? This is Matt Greenblatt with Greenblatt Agolnik PC, and this is Keeping It Real in Real Estate. I hope everybody's doing well. I hope everybody's staying safe and healthy. Just wanted to jump on here today and tell you about a question that I had from a client earlier this morning, in which they asked me whether or not they should take title in their property that they're purchasing as a tenant in common or a joint tenant with a right of survivorship. So in New York, you can take title to property, which means that how your names are listed on the deed, or shares of stock if you're purchasing a co-op, and it will be your names will be filed by either tenants in common or joint tenants with the right of survivorship, or there's a third one which is for married couples. It's called tenants by the entirety. Okay, so I want to kind of explain to you the differences between the three, and so that you can make kind of a informed choice when you are purchasing a property with another person or a spouse or a family member, and you could legally have it the way you want, so that your investment or your equity in the property is protected upon your passing. So that's really the concept here. Really, these designations will tell legally what the other party has to do or what the courts have to do in the event on your passing. So this doesn't come into play when there's only one owner, but when there's two or more owners, if you want to, number one, take it as tenants in common, what happens is that upon the passing of one of those two owners, the deceased owner's share of the property will get passed down to their heirs, either by will or by the New York state and intestate laws. Okay, so it doesn't go to the other owner; it goes down to their heirs. Now, the thing is, with tenants in common, okay, each co-owner can own different percentages. They do not have to have 50% ownership each. Okay, one could be 30%, 70%. It doesn't really matter. However, what is important is that even if you don't have equal percentage ownerships, each owner is entitled to occupy and use that property, the entire property, okay, as long as they own it, right? So that's tenants in common. Conversely, what you have is what's called joint tenants with the right of survivorship. Joint tenancy or joint tenant with the right of survivorship is a situation where you have two owners, and upon the death of one of the owners, the other owner gets that deceased person's ownership interests, okay? And with a joint tenancy, it's equal shares, right? Unlike tenant in common, where they can be unequal, in joint tenancy, it has to be equal. So they're equal share owners. Upon the death of one, the living owner obtains the ownership interests and portion of the deceased, all right? Now, the third concept is called tenants by the entirety. Tenants by the entirety is when it's kind of like joint tenants with right of survivorship, but it's for a married couple. Okay, so when a deed will say John and Jane Smith, comma, as tenants by the entirety, it really means that they're taking ownership in a similar situation as a joint tenant with a right of survivorship. There's a couple of different nuances and which I don't need to go into right now, but it's, for the most part, it's virtually the same as joint tenants with right of survivorship. So that's kind of the designation when you're a married couple. Now, here's the thing. In New York, if you're not a married couple and the deed to the property or the shares of stock of the co-op do not list anything after your names. It doesn't say tenants in common. It doesn't say joint tenants with right of survivorship. It doesn't say tenants by the entirety. There is a presumption that when the two parties or more are not married, then the presumption is that they meant to be doing it as a tenants in common, okay? So that's very important, that if you're not going to put that on there, that's what it's going to be presumed. If it is a married couple, then it's going to be presumed that it is a joint tenant by the entirety. One other thing is that when you do have a tenant in common, the percentage ownerships typically have to be listed on the deed as well. So if it's Jane Smith, 70%, Tommy Jones, 30% type of thing. And you could have multiple owners as well. So these are kind of the different ways that you could take ownership to a property, and you want to kind of consider, at closing or before closing, so that it could be listed the proper way, and that it could reflect what your intentions are when you purchase the property. So I hope this is helpful. I hope you gain some insight as to the different ways you could take title in New York. And if you have any questions or comments, please feel free to comment on the video. Please subscribe. Please like this video, share it with your friends, your family, your colleagues. Greatly appreciate that. And if you want to have a free consultation or speak further or any questions, feel free to schedule a call with me. You could go to greenblattschedule.as.me. Again, that's greenblattschedule.as.me. And you could schedule a strategy session with me, or information session, or really anything. So again, hope everybody's doing well. This is Keeping Real in Real Estate, and my name is Matt Greenblatt with the law offices of Greenblatt and Agolnik PC. Have a great day. Have a great night. Take care. Bye.